But let's start with the breaking news here out of Michigan. Just hours ago, the jury said guilty on all counts. Unprecedented verdict against mother Jennifer Crumbly. Involuntary manslaughter for the 4 deaths that her son Ethan Crumbley committed when he shot and killed classmates in 2021. Here's the moment Crumbly heard the jury's decision.
On count 1 of involuntary manslaughter as to Madison Baldwin, we find the defendant guilty of involuntary manslaughter. On count 2 of involuntary manslaughter in regards to Tate Muir, we find the defendant guilty of involuntary manslaughter. On count 3 as to involuntary manslaughter regarding Hannah St. Juliana, we find the defendant guilty of involuntary manslaughter. And in count 4 of involuntary manslaughter against Justin Schilling, we find the defendant guilty of involuntary manslaughter.
It's the first time a parent's been convicted of a school shooting carried out by their kid. And this kid was mentally ill, this teenager. And that's really the crux of it. What was she supposed to do under the law to keep other kids safe from her kid? The jury deliberated for a while, asked questions, went about 10 hours. So why did they come to this conclusion? What does it mean in Michigan, but also in terms of what other states may do when it comes to school shooting and consequences? Let's bring in attorney Misty Marris, Florida prosecutor Dave Aronberg. Okay, Dave Aronberg, you saw this coming. What does the precedent mean? This was not a specific law that Michigan had come up with. They applied involuntary manslaughter 2 tests. One was a low bar, that you had a duty to keep this weapon and ammunition safe and out of the reach of a mentally ill teen, and you didn't. The second theory was that you are guilty for his murders because you should have controlled him more and stopped him from doing that. Do we know which theory mattered? Now, it doesn't matter under the law. They could have picked either one, the jury. In fact, they could disagree on it. But do you think that that second theory is really the one that could make a difference in terms of the national dialogue?
Good to be with you and Misty, Chris. It's hard to say at this point. I think we'll know later which one prevailed. But I would not look at precedential value here as much as others because we've never seen a case like this with these kinds of egregious facts. Look, people are saying, well, now parents are going to be responsible if their kids become school shooters. Well, no, unless you did something like she did. And I think there were 3 moments in this trial that led to this verdict. First, it was the image that the prosecutor showed of the lock, the gun lock, that was still in the case. And that showed that this individual, Jennifer Crumbly, lied on the stand about how, they locked up the gun. And that was, I think, very compelling to the gun owners, responsible gun owners and hunters on the jury. Number 2, on the stand, she said that she wouldn't have changed a thing. She wouldn't have done anything differently. That was so cold, so callous, made her very unlikable. And third, the kid drew the killing. He showed himself shooting people, saying the thoughts won't stop, please help me, blood everywhere. Jennifer Crumbly knew about this and did nothing about it, wouldn't take the kid home, wouldn't check the backpack, didn't even mention to the school officials that he had access to a gun. So, yeah, if you have a case like this in the future, yes, the parents will be prosecuted, but I don't think we'll ever see something quite like this again.
The gun safety, Misty, I don't think is a big dispute. We've just never seen it applied to, usually these school shooters die in the act. Not usually, it happens often, okay? And usually it's that, well, they've suffered enough, so we're not gonna go after them criminally. Maybe people go after them civilly. But this second theory that Dave is discounting because the facts are egregious, I don't know. You have a kid who's mentally ill, you say you didn't know what he or she was capable of, and that you're shocked by what happened. The school had a lot of the same facts, and they didn't act. How clear is the standard now, Misty?
Right. It's always going to be a very, very fact-specific standard, as Dave said. And I do think we heard a little bit from the jury during the trial and during their deliberations where they asked about a specific question relating to how do they know how Ethan Crumbly got access to the gun? Can they make an inference based on what was not presented? And then we heard a juror on the way out of the courtroom today say that they really looked to who had the gun in their possession last, which adult. And they looked at that person as Jennifer Crumbly. So it seems that the jury was very focused on the safety procedures and protocols of gun storage. But to your point, Chris, we could see these cases, especially in these instances of mass shootings, and again, it will always be fact specific, but you could see prosecutors moving forward with these types of cases with more frequency because it isn't very clear and it's always fact specific, and it really rises and falls with the idea of what was foreseeable. And that's going to be different in every circumstance. So will this law continue to be tested? I think it will be.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.